hate to interrupt the terrific conversation that's going on, because it's always so exciting to see that happening in this space, but the hour is upon us, so I'm going to ask you to pause the informal conversation and come back to it later. My name is Jennifer Lauren. I'm a professor here at the law school, and my job this afternoon is twofold. One is to welcome you to today's talk and celebration of Professor Karen Engle's latest book, Toward an Abolitionist Human Rights Court, Rethinking Responses to Gendered and Racialized Violence, which, among other things, applies a critical abolitionist lens to the trajectory of criminalization of human rights violations, including gendered, racialized, homophobic violence. We will be hearing about that today from Professor Engle, and also hearing further thoughts about it today from Professor Rachel Rebouchet. And so my second job for today is to just introduce these two terrific colleagues of mine who you will be hearing from. So Professor Karen Engle is the Minerva House Drysdale Regents Chair in Law, and is also the founder and the co-director of the Rapoport Center, which is the under whose auspices we are gathered today. Professor Engle writes on the interaction between social movements and law, especially in the fields of international human rights law, international criminal law, Latin American law. We'll be hearing a lot about pieces of that today. Law students in the room, in particular, should look out for Professor Engle's courses in public international law, international human rights law, and legal theory. After we hear some overview remarks about the book from Professor Engle, we will hear a response to the book from Professor Rachel Rebouchet, whom I'm particularly excited to introduce this morning, as she is one of our newest colleagues here at the law school, having joined us this year from her position as professor and dean at Temple University Beasley School of Law. Rachel is the G. Raleigh White Chair in Law, and she researches and teaches in many fields: reproductive health law, public health, family law, contract law, feminist theory, all of which she will be drawing on today and engaging with Professor Engle's work. So after some overview remarks from Professor Engle, some response from Professor Rebouchet, I think Professor Engle will have a brief chance to reply if she wants it, and then we will open the session to Q&A before closing at 1. So that is how we will proceed. And with that, please join me in welcoming Professor Engle.
Thank you, Professor Lauren. Thanks to you all for being here. And I want to make sure and identify Cooper Christiancy for you all, who's the Rapoport Center's academics and research manager. He'll be running the Q&A. And I want to thank him for organizing this talk, which is a part of a new series that he's also organizing on faculty book talk. So I realize I rarely am the main speaker at a Rapoport Center event, so it's a little strange, because I want to welcome you to the Rapoport Center and tell you about this series and then get into my book. Thanks again to Professor Lauren for the intro, but also for helping to organize a conference that I think Denise Gilman helped organize as well. I know Ariel Dulitsky was there. In a time before COVID, we had a conference on human rights and abolition, and believe it or not, I think this book eventually emerged from that. And of course, I'm thrilled to be here with Professor Rachel Rebouchet for agreeing to be a respondent, and though she is new to UT, I've had the pleasure of long being her colleague in a broader sense, and you'll see she's a wonderful interlocutor. So this little book, and it's a little book, is called an element. So I wanted to say something about that. Cambridge Elements has these series on all kinds of topics, and I recommend many of them to you. I mean, I think it's worth taking a look at their website and seeing what they have. They can't be longer than this, which is 35,000 words. And this particular book is the first in a series on international law and society. And the series editors asked all the authors to give a critical overview of some part of international law, and in my case, that was human rights law, beginning with a problematique and offering a provocation. So no small thing. And though the talk and book are about human rights, I am hoping that you'll see resonances in other areas. And with that, I just want to take a quick poll to get a sense of who's in the room. So how many of you are studying law or have studied law, are coming from the legal field? Okay, don't worry if you're not. Actually, I should ask you, how many of you have, would you say, read about prison or police abolition? Some of the same people, maybe. And what about human rights law? How many of you have studied human rights law? Okay, great. And how many of you have heard of the European Court of Human Rights? All right, that's going to be quick then. So my problematique is about the compatibility of movements for prison and police abolition with human rights law movements and discourse. And specifically, here's how it plays out. While most abolitionists have long considered human rights to be central to their aims, most human rights advocates have actually not prioritized or even supported prison or police abolition. The two groups, of course, agree on many matters and often see each other as allies. Yet, while abolitionists refuse the ideologies and practices of the carceral state, human rights advocates have actually grown to depend upon them. So that is that human rights law today, though it hasn't always, regularly imposes on states the obligation to police, investigate, prosecute, and punish at least serious human rights violations. So in part to highlight the differences in approaches that are often missed by abolitionists as much as anyone else in these movements, I use a broad range of prison and police abolitionist thinkers and activists over the past 50 years to argue that human rights law and advocacy should stop calling for increased punishment or policing. So that's my provocation. In many instances, courts and advocates use criminalization and even enhanced penalties to call attention to significant harms that they rightly believe should be attended to. In doing so, they deploy the expressive function of criminal law. But I maintain that they also not only prop up and foreclose alternatives to the criminal punishment regime, which has its own racialized and gendered harms, but they provide an alibi for adjudicators and advocates by facilitating their ability to claim to address serious human rights violations without actually attending to structural harm. Now, in the past, I've identified and critiqued this turn to criminal punishment in human rights law and advocacy, including in women's human rights advocacy. And I even realized I published some of that work in a book that Rachel edited. This book moves beyond that critique by using abolitionist arguments to propose alternatives to calling on states to investigate, prosecute, punish, and police in response to serious human rights violations. And my hope is that doing so will lead to the flourishing of many of the alternatives that abolitionists call for, taking into account the specificities of each state and embodying the abolitionist attachment to experimentation. So sometimes they sound like federalists, and you'll hear more of that. So this book is but one part of a larger project on human rights abolition, and I decided to start with the European Court of Human Rights. And I'll often refer to it as the ECTHR. The court is the oldest of three major human rights courts, regional human rights courts, having been established in the 1950s by the European Convention on Human Rights. Today, it adjudicates claims of violations of the convention, primarily brought by individuals against Council of Europe member states, which are all parties to the convention. So I focus on Europe for several reasons that I think are worth stating. First, early abolitionist thought largely emerged from Europe, particularly in the prisoners' rights movement. Second, at least certain parts of Europe and the Council of Europe as a whole have in fact pursued a number of important penal reforms. Third, the court is the only human rights body I've seen that has acknowledged the ways that, as its former judge Françoise Tulkens, a Belgian criminologist and legal scholar, put it, human rights had shifted from being a shield against criminal law in the practice of the court to becoming a sword. Relatedly, Tulkens constantly reminded the court that criminal law should be the last resort, which is an idea some of you might have heard of penal minimalism, that has a fair amount of traction in a number of states in Latin America and Europe. And the idea is that criminal law should only be used as the last resort. It falls short of abolition, but it arguably goes a long way. And finally, while I think there's much to learn from early abolitionist thought in Europe, Europe has a lot to learn from contemporary abolitionist movements in the US. Europe might not have the mass incarceration rates that we have, but the region is far from immune to racialized and gendered violence, which I think is important to point out. So continuing with my provocation, I argue that the ECTHR and the advocates that engage in strategic litigation before it can and should break away from the dominant carceral trend in human rights. And they can do so first by returning to some of their earlier approaches to penality that I just pointed out. Second, heeding their own insistence, and I can say more about this in the Q&A if there's interest, that the European Court is a human rights, not a criminal court. That's actually common for human rights courts to say, we're not criminal courts. And expanding their remedial imagination. So to make that argument for you now, I'll first briefly consider some similarities and differences in the origins of penal abolition and human rights movements, and set forth the debates around what abolitionists call non-reformist versus reformist reforms. Next, as one way to see how things have shifted over time, I'll home in on two areas where I think the court has been the most anti-abolitionist and yet the least critiqued, and those are cases involving gender, sexual, and racial-based violence, as well as those involving policing. And I'll conclude by sketching what I think could be the contours of an abolitionist-oriented court. I don't think it's a very radical call, but it's aimed at getting the court to take seriously its commitment to racial and gender justice. Simply obligating states to police and punish should no longer be a way out for the court or for most states. So, human rights and abolitionist movements. As I already mentioned, abolitionists often state their claims in, or at least see themselves as aligned with human rights. And that's true, ironically, even in the United States, where arguably human rights are often seen to carry little weight. And there are reasons that abolitionists might be sympathetic to human rights. And that's for several decades, human rights law and movements focused largely on due process rights of the accused, on prison conditions, and on even getting people out of prison. And early human rights instruments and institutions made clear that prisons were meant solely for the purpose of rehabilitation. And you can see that in the 1966 International Covenant on Civil and Political Rights, to which the U.S. is actually a party. At a doctrinal level, the European Court has long enshrined the rights of the accused, particularly those found in the European Conventions, prohibition of torture and inhumane or degrading treatment, right to liberty and security, right to a fair trial, and other due process guarantees. And these provisions, along with some of the court's jurisprudence interpreting them, are actually what Tulkens and others point to as evidence of that shield function that used to be so dominant in the jurisprudence. Relatedly, in Europe, penal abolitionists in the 70s were largely connected to prisoner rights movements and struggled with many of the issues that abolitionists, if not human rights movements, struggle with today. Namely, they asked, should those who argue for abolition in the long term support or even promote in the short term the more humane treatment of prisoners? Most notably, Norwegian sociologist of law Thomas Mathiesen, arguably the leading thinker on penal abolition from the 1970s until the mid-21st century, coined the language that's now key to abolitionists throughout the world, distinguishing between reformist reforms and non-reformist reforms. So reformist reforms, which he opposed, are changes which improve or build up the system so that it functions more effectively. And he gave examples of increasing prison staff, building new prisons, and at least doing that as a way to get better conditions. Abolition is made more difficult by these reforms, he argued, partly due to, quote, the renewed legitimacy which an improvement bestows on the system. And so he supported non-reformist reforms, which are, quote, changes which abolish or remove greater or smaller parts on which the system in general is more or less dependent. So not the whole thing, but small parts or greater ones. And as leading U.S. abolitionist Ruth Wilson Gilmore has put it, non-reformist reforms are those reforms that, rather than supporting the carceral state, at the end of the day unravel rather than widen the net of social control through criminalization. So through this lens of reformist versus non-reformist reform, human rights attention to due process, prison conditions, and over-policing, while important, might fall short of and sometimes even conflict with abolitionist aims. So let's turn to a little bit of the case law with that in mind. Because I think that it arguably undermines even the best non-reformist reforms. Lawrence Leverson and Natasa Mavro-Nicola have identified what they call coercive human rights, which might be a term you'll run into. And they see that in the court's jurisprudence, noting that it has used some of the same provisions that I just mentioned that support the rights of the suspected, accused, and convicted to different, indeed more carceral ends. In particular, the court has held states accountable for not criminally investigating, prosecuting, or punishing human rights violations, as I've already mentioned, and has often found sentences to be too lenient, and they'll actually say, or manifestly disproportionate to the harm. So I largely agree with them, but I push their critique a bit further here with an eye toward two aspects of the jurisprudence that's received little critical attention. And again, those are the ways that the groups that are seen as historically subordinated or vulnerable are often used to justify criminal sanctions, and relatedly, the court's calls for increased policing. So on the first, part of the court's jurisprudence, in fact, the part that's often seen as its most progressive jurisprudence, suggests that those who are vulnerable or part of historically subordinated groups are particularly deserving or in need of criminal law. So vulnerability, some argue, acts as a magnifying glass. It makes ill treatment look bigger, and increased punishment in general seems aimed at doing that. One area in which the court has used vulnerability to increase the positive obligations on states is interpersonal, or what it calls domestic violence. And in Opez versus Turkey, to give you a sense of when this started appearing as sort of a more mainstream response, in 2009, the court handed down a landmark case finding that the state violated the right to life, as well as prohibition on torture and discrimination, by not protecting from domestic violence victims that it looked at and said were particularly vulnerable. And later cases ruled that actually anyone subject to domestic violence is per se vulnerable, and then began to find states liable for failing to include domestic violence as either a separate offense or an aggravating offense, which is to say that it should be punished more harshly. The courts also required increased criminalization or punishment for racially motivated violence. A lot of those are police cases with police violence against the Roma, and many claims having been brought in Italy and a range of Eastern European countries. So in Nachova versus Bulgaria in 2005, the court found that Bulgaria violated the convention because it didn't distinguish in its law between cases of excessive uses of force and those of racist killing. And And in subsequent cases, the court applied the same logic to non-state violence, requiring states to make racially motivated violence a separate legal offense, which is around the discussion of hate crimes there, as well as in the context of homophobic or transphobic violence, which the court has basically followed the race cases on. Now, many human rights NGOs have been behind the strategies, so that's the connection to the advocacy, that led to these decisions, or at least have lauded them when they appeared. And in part, they've done that, again, to bring greater attention to the harms. But I'm more circumspect, agreeing with British criminologist Barbara Hudson, who in a different context stated that, quote, what should be taken from feminist, anti-racist, and other zero-tolerance campaigners is that racial, sexual, and domestic violence should always be taken seriously. So I absolutely agree with her there. I also agree with her, however, that we should take from abolitionists, quote, that punishment is morally problematic and that involves the state inflicting pain or deprivation on an individual, deflects attention from the victim, generally offers little by way of protection, and usually makes people worse rather than better. Now, that position is far from new, even among feminists, though it's often forgotten. And, part of this in looking, that's true in Europe too. So French feminist Françoise Verger discusses the women's liberation movement that she says has too often been forgotten from the 70s, and its refusal to appeal to criminal law to respond to interpersonal violence against women, because they said, quote, pretending that respect for women will be measured in the number of years behind bars. They're against it because it pretended that respect for women will be measured in the number of years behind bars handed down in trials. And since the beginning of hate crimes legislation, many have pointed out, who were supposed to be protected from it, have pointed to the problems of placing the safety of subordinated groups in the hands of the very criminal legal system that's a major perpetrator of violence against those groups. So the challenge then is how to channel that condemnation in ways that don't deploy the coercive and carceral power of the state, but address the structural roots behind them. So when I look briefly at some cases around policing, which is to say that that many of the court's decisions, including a number I've already discussed, fault the police for inaction or insufficient action. And especially in cases where they see against the violence against groups that are marginal or vulnerable. And this lack of police action sits in tension with many of the cases, of course, in which the police have overacted, including against many of the same groups. But I think it should raise the question whether, especially given all we know about police abuse nearly everywhere in the world, a human rights court should be calling for more policing. Maybe I'll just say a word. The passivity of police comes up in almost all of the interpersonal violence cases. And it also comes up in the context of some protests. So a relatively recent case against Georgia, I think, provides a vivid example. The state had deployed 2,000 police officers to protect participants in an LGBTQ public rally. And when counter-protesters committed acts of violence against those in the rally, the court faulted the government for, quote, not equipping law enforcement officers deployed to the scene with appropriate riot gear. Yet, the court reached that conclusion alongside a finding that at least some of the police had in fact aided the counter-protesters by opening up the cordon that the police had erected. Arms and riot gear in those circumstances would likely have made the situation worse. And it doesn't take much to imagine those are the kinds of cases in which the police will use the case or the state to call for greater funding, which is a definite reformist reform, which I'll come back to in a moment. So these cases, too, have been lauded by human rights advocates, not heeding many critiques, even by non-abolitionists, of calling for more policing. So in the context of interpersonal violence, many feminists have noted in the United States, for instance, that increased police response has led to increased incarceration of victim survivors, particularly when police are required to make an arrest in those cases. And many also emphasize more generally that police officers pretty much everywhere are also some of the greatest perpetrators of domestic violence, which is the case in at least one of the European Court rulings I look at. And abolitionists also identify increased police training, which is often the response, as a reformist reform. As U.S.-based critical resistance explains, not only will, quote, more training require more funding and resources going to police to develop and run trainings, but even promoting trainings furthers the belief that better training would ensure that we can rely on police for safety. Further training, they say, tends to increase the tools, tactics, technology that police have at their disposal. So, what could a human rights court do? Abolitionists have, over the past 50 years, and it seems like some of you are familiar with some of what they've proposed, they've produced many alternatives to penality, prisons and policing, with the long-term aim of nullifying the harms that we turn to the police and prisons to resolve. So these alternatives range from the creation of transformative, community-based justice mechanisms to the redistribution of funds that I already suggested, to ensure broad-based social protections and redress inequality. And abolitionists have also continued to propose a variety of non-reformist reforms within the system, including prisoners' rights, sentence reductions, and decriminalization, while generally eschewing alternatives that extend the state's carceral reach. And my query, so I'm not trying to redo all of that or present that in a new way. Really, my query is what role a human rights court might play in facilitating the implementation of these and other alternatives. So when put that way, my plea is, as I said, relatively modest. And so I'll give you a sense of how I think the court might participate in a weakening while also better addressing or thinking differently about the needs of victim survivors and effectuating structural change. So perhaps the most straightforward abolitionist change that the court could make is to stop imposing those positive obligations on states to use or wrap up their penal apparatus to respond to serious human rights violations. And while not requiring that penalty as a necessary first step, it's of course not sufficient, because it would fall short of the court's commitment to prevent and hold states accountable for gendered and racialized violence. So I'm not saying that shouldn't happen. It absolutely should. But rather than imposing positive obligations on states to increase penalty and allow states to use that as an alibi, it should call upon states to use other tools, existing and new, aimed at both repairing individual harm and remedying structural conditions. And so instead of focusing on the 3 Ps of policing, prosecuting, and punishment, as some have put it, it should focus on a different 3 Ps: prevention, protection, and provision of redress. Now, the courts could give states a fair amount of latitude, this is where the federalism comes in their choice of, though not their commitment to non-penal responses. That would have the benefit of the experimentation that abolitionists call for, while also holding states accountable when it's determined that they've not put in place sufficient policies or provided sufficient resources to address the harm at a structural level. So it might require investment in social services, education, health care, community organizations. It might even find that states have an obligation to change other, often backgrounded laws, like family law and property law. And in addition to promoting structural change, the court should also pay more immediate attention to the victims that come before it, without assuming that criminalization is in fact what victims want or need, which is a self-perpetuating idea. So it would take a page from Mathiasson, who in 2015 called for, quote, not a punishment scale for offenders, but a support scale for victims that would include economic compensation from the state, symbolic support in situations of grief and sorrow, shielded places where victims who need protection can go, et cetera. And in terms of economic compensation, I look at how the court it's actually been criticized for having very little transparency over when and how it decides on compensation. So it could be much more clear about that and show that it values remedying some of these cases. And finally, given that so many alternatives proposed to criminalization are often community-based, the court would want to be clear about the limits of what states alone are able to do. And that's a little tricky, I think, for human rights courts. But perhaps states could be allowed to meet some of their obligations by delegating responses to community-based NGOs, but they shouldn't be the same NGOs that are bringing the cases before the court now. They should be NGOs that are committed to finding alternatives. So, in conclusion, abolition is a long-haul project, and US-based abolitionist Mariam Kaba emphasizes, again, that abolitionist praxis is not a blueprint, but a process of experimentation. So what I'm hoping to do here is not only to engage in that process, but to find a way for state and non-state actors to do so as well. Thanks.
We'll get started with question and answer. We have the room till 1:30, but I know many of you are law students who have to get going at 1. So we will prioritize law student asking questions first. So if you have a question, we'll take about 2 to 3, batch them together.
Thank you for your remarks. My question is not directly under the European Court of Human Rights, but in light of the recent development, the recent ruling, domestic ruling in Brazil, sentencing former President Bolsonaro to 27 years in prison, there's no denying that there's widespread jubilee for Brazilians, for many, many Brazilians. How should we think about that kind of collective moral satisfaction through the lens of an abolitionist human rights court? Can an abolitionist approach account for or even honor those moments where punishment feels morally justified at a societal scale? And do you see that there's space for non-reformist reforms towards dismantling those punitive logics?
One other question. We'll batch them together. Well, Professor Engle, why don't you answer that one? And could I ask you to stand up at the podium so we get the recording?
Well, we have something to say. No, thanks, Carla. That's a great question. And of course, and I've been thinking about it, not surprisingly. And it's interesting that you say that there's collective moral satisfaction, because there's also, there's a lot of collective anger at it too. And, you know, and they're talking about it in the historical context and who has gotten impunity in the past and who hasn't. And I mean, this would be another subject of a discussion for an hour or something. Except that I guess I do think that, I mean, I'm nervous that the politics have been there on both sides very strongly with regard to Bolsonaro. And of course, what it's saying, like Brazil will do it and the US won't do it. And that also that gets tied up in what progressive politics are, I find a little problematic. So I think it's hard with this project. I mean, in abolition generally, you know, I think any abolitionist will say, yeah, there are times when they're like, if somebody's going to get it, couldn't have been a better person to be selected. But of course, that the idea is to build a society in which we're not having to then ask that question and be in that moment, and in which he might have been in power, but he wouldn't have engaged in the activities the criminal activities for which he was convicted. So, and I worry about the backlash. Maybe that's what I would just say.
Other questions? You can open it up to the whole group. You don't have to be a law student to ask a question. Here, and then there, and then
At the beginning of your speech, you critiqued the idea that the violence that women or survivors face can be fixed by someone being put behind bars for a certain amount of time. What do you think separates a financial remedy from that sort of like superficial nature of we can just equate that to like women being free from violence?
Wait, I'm sorry, because somebody can you just say, so with the financial, the question was?
Yeah, like the solution of a financial remedy or damages being awarded, what distinguishes that from like a superficial understanding of like we can save women from violence or survivors by like putting an economic amount on it.
Yeah, great.
So, thank you, Karen. We've been discussing this for the last 15 or 20 years. I'm on the human rights punishment side.
You want to punish human rights?
Yeah, in part, yes, for out of frustration that we are not getting where we want. There are many, many comments and questions. One is the historical moments where you place kind of this turning from a more protective, more abolitionist agenda of the European Court to the more punitive one. And you say the last 50 years, but the examples that you provide are from the 2000s, and all the cases that you cited are from Turkey or Eastern Central Europe that changed the composition and the type of cases that the court started to receive in the late 90s, early 2000s. So is that a reflection of a change in attitude or a change in the type of cases that the European Court started to receive and had to deal with? And the second question is your final proposal on the 3Ps or 6Ps. I see that the Inter-American Court is embracing the 6Ps. And you wrote that it overemphasizes the first three, but the Inter-American Court deals with the other three as well. So is that a model to start? How you would place those two courts in dialogue?
Great. Should I go ahead?
Yep.
So thanks for the question about the financial remedy. And I was actually going to say, if Rachel, Professor Rapoport and I disagreed about anything, it might be on that point. And that's partly, I did have a lot more emphasis on the idea of compensation. But remember the quote that I gave from Thiessen, like that was only one aspect. And it was compensation to redress, so we'll come back to that, some of the harm. But also it would have to be with providing safe spaces for people, but also working to affect the underlying structural harms. But the reason why, so if you were to think about, and actually I don't think Rachel wasn't saying that, so if that were the only response, right, that would be problematic. And I actually, though, had it as a much stronger response. And in workshopping the drafts of the book, I got a lot of pushback for monetizing harm. And also, it's just the way that the compensation works in the European Court is so, it's related to, you only get, actually, you get, the remedy is tailored to the currency and what's considered to be a lot of money and a little money, and there are all kinds of issues, and the state has already not to have provided something, and then are those countries, what does that do to the budget, and that's a kind of restructuring, and why this harm versus other harm. So there are a gazillion problems with it, so, which is why I've now made it like, let's just be clear about what standards are being used, and when we do award, when the court does award damages, being more aware of that. Great questions, Ariel, which also allow me to say things I didn't get to say. So in terms of the historicizing, so what I'm saying is abolition has been there for 50 years, and the human rights movement also started 50 years ago, and they were more in line for a really long time. And I think I can show that in the Inter-American Court of Human Rights, at the UN, and have, because like I said, this is part of a bigger project, so I've actually done a lot of that work in a lot of different places. And it seems that it's pretty much the late 80s, early 90s when there starts to be a shift. And if anything, it's a little bit later in the European Court of Human Rights. But I wouldn't pair it exactly to when the Council of Europe grew after '89. I mean, maybe there's some coincidence there, but there's more than that in the sense that you're absolutely right about the cases. And I have presented this to European audiences, to European human rights audiences, and they're kind of at a loss as to, I mean, I'll ask, somebody tell me why these are, you know, mostly Central and Eastern European cases, and it's surprising to me how I can't get, you know, there's not an obvious response to that. So part of it is where the advocates are bringing claims. Part of it is what they're able to do in some states at a state level as opposed to going to the European court. There are cases also, especially with regard to the Roma, like I said, against Italy. But the Roma advocacy organizations have pretty much focused on Central and Eastern Europe. And that's where a lot, you know, so much of the violence is. But I don't think that's responsible for the overall shift. Those are just examples of that one part that I'm trying to show. And then I think with the Inter-American Court, absolutely, and I was thinking about this in response to Professor Rebechet's responses as well, because the Inter-American Court does have a much broader conception of damages and reparations, as you well know. Now, I will say with regard to the 6, I make it pretty clear, I think, in the book that you can't say that you're going to achieve the last 3 by using the first 3. So, right, the idea is that punishment is being used to say we are preventing and providing reparations, and that's what I want to avoid.
All right, I think that's it for now. Please feel free to stick around for a little bit if you'd like to ask questions one-on-one. But thank you all for coming, and thank you, Professor Engle and Professor Rapoport.